from here. And it's been 2 months since a Cape Coast High Court annulled the parliamentary elections of the Assin North constituency, while the controversy over whether or not the NDC candidate can hold himself as MP for the area pending other court cases rages. We look back at what has brought us to this point. My colleague Dennis Wedam has the wrap.
The Cape Coast High Court on July 28 declared of the Assin North Member of Parliament James Kweson's election as void for owing allegiance to a different country contrary to the laws of Ghana. The court ruled for a fresh parliamentary elections to be held in the constituency. This followed petition by constituent one Michael Ankoma Nimfa, who challenged the legitimacy of the election. The petitioner's case was that the MP at the time of filing to contest the 2020 parliamentary elections had not renounced his Canadian citizenship and thus held a dual nationality. The petitioner insisted that the close of nominations on October 9, 2020 as the Assin North MP had not still renounced his Canadian nationality. Presiding Judge Justice Kwesi Boakye in his ruling said the MP violated constitutional provisions and other statutory provisions that guided the country's elections. After 8 months of litigation, the matter was decided in favor of the petitioner and a fresh election ordered. Consequently, the High Court issued an order to Parliament for the seat to be declared vacant, but the Speaker would not yield to the order, arguing the evidence before him does not show time is ripe for such an action. Kwesson had represented the constituency in Parliament for the past 9 months and has taken part in key decision-making, including the election of the Speaker.
And as we know, the Speaker of Parliament, Alban Bagbin, has declined the invitation to declare the Assin North seat in Parliament vacant because of a court action which is currently pending. We know that the NDC candidate is in court challenging the Cape Coast High Court's decision to annul the parliamentary election. James Kweson's victory was challenged in an election petition and was consequently annulled by the High Court on July 28. The Speaker says the matter is not concluded. A letter from the Parliamentary Service dated September 3 explained that it will be premature for the seat to be declared vacant. So let's bring you a lot more detail from the letter that the Clerk of Parliament wrote to the Judicial Service, especially the court, which decided to write to Parliament for the Speaker in particular to declare the Assin North seat vacant. According to the letter from the clerk to the court, it says that the decision will be premature because the case is still pending in court. We also know that the NDC candidate in question is in court challenging the declaration that has been made by the court. Now, let me just quickly run by you some of the details of that letter. So it says, prior to receipts of this process, which is the letter written from the court to the Speaker had received certified true copies of documents from the lawyers of James Kwesson, who is a member of Parliament for Assin North constituency. Now, it goes ahead to say the matter in question is still sub judice and has not been concluded by the courts. And so that's one of the reasons why the Speaker says he cannot declare that seat vacant. The Speaker says it is not clothed with the legal basis to make a pronouncement on the matter and cannot go ahead to declare the occurrence of a vacancy pursuant to the Constitution and the standing orders of the House. So those are the details that the Clerk of Parliament wrote to the court on the reasons why they cannot go ahead to declare this particular seat vacant because the matter is not concluded. We'll be joined by a constitutional lawyer to have a conversation on this, whether or not this is premature and what the options are in terms of this. What are the provisions to declare a seat vacant in Parliament? And with this particular case in focus, what are the options? As the Constitution in Article 117, 118 has already said, that a member of Parliament cannot be served processes while he's on his way to Parliament or his way away from Parliament. And so those are some of the issues that we're going to be getting the constitutional lawyer to engage on this subject. As and when he joins us on the line, we'll be getting the perspectives from him. Justice Abdullah is a constitutional lawyer. We'll be getting him to speak to us shortly. But while we wait to get to him, the Deputy Majority Leader has been reacting to this. He says the Speaker's decision to decline the announcement is apt.
I would say so far commendable. we've had some few issues with his ruling, but that is what it is. So we hope that he will do more to ensure inclusiveness, and we have no doubt in his ability to do that. There's more room for improvement.
Great to know. Today we are learning of the Speaker Bagman's decision to decline to make the Assin North seat vacant. Surprising turn of events for some. Surprise for you?
Well, it's not a surprise for me. Speaker Bagman was on the side of the law. I think that the service to the Speaker was even wrong in the first place. I mean, to me.
Who should the service have gone to?
Because the order of the court was specific. The order directed EC to conduct fresh election. The order nullified or annulled the election as conducted by the EC. So it has nothing to do with Speaker. He doesn't have to come in any way. So his letter was right. Two, and very importantly, if you look at the content of his letter, he referred to
Speaker Bagman was wrong. Should the letter actually even be coming from the Electoral Commission instead?
No, I don't think Electoral Commission must even write to Speaker. Neither do I think that the court's process should have been served on the Speaker. There are parties to the suit, and by that, the orders are to be executed in its specific terms. It's different from somebody dying. If somebody is dead, you write to Speaker, then the Speaker would declare vacancy.
It's also different when someone crosses carpet.
If somebody crosses carpet, Speaker would declare vacancy. If somebody resigns,
is the legal undercurrents that make this challenging for Mr. Speaker to pronounce?
I won't accept the word undercurrent. The position of the law, specifically, there's a stay of execution. Once there is a stay of execution, Mr. Speaker cannot do anything. In any event, there was no obligation on him to do anything. The obligation was on EC to act. So really, the enforceability of the order was rightly at the doorstep of EC. I would say that serving Speaker was merely superfluous.
Right.
The practice is that once a stay of execution is filed, it operates as a stay until same is dismissed or otherwise. So yes, as we speak, Mr. Kwesi has filed a stay of execution pending the hearing of his appeal. I'm sure parties to the suit will deal with it. I mean, as in the respondent. So let us wait for the decision of the Court of Appeal on his stay. Then we can talk again. But once the stay is determined, depending on which way it goes, if the court holds a view that the stay is there, is granted, what it means is that he will remain an MP until the final determination of his case.
I wanted to ask because.
So you heard the Majority Leader, Afenyo King, speaking to my colleague Jifa Bampo. Let's get a lot more perspective into this. Private legal practitioner, Justice Abdullahi joins me via Zoom. Thank you for joining us. Let's forget about the circumstances when an MP, for example, dies or crosses carpet and then the seat then becomes vacant. In a scenario like this, in which we're having in focus, what are the determinants to declare a seat vacant in a scenario like this, considering the Article 117, 118 provisions of the Constitution?
Well, indeed, when events like this happen, the Speaker is informed and it goes through the clerk that indeed a seat has become vacant. Once duly informed, the Speaker communicates this to the Electoral Commission official. They may have heard it in the grapevine, they might have seen it on social media or even on regular media. But until the official communication is done, either by the family or some other positive steps are taken to verify the accuracy of the information as to the death of the person, without necessarily having to wait for the family to communicate. That seat remains the seat of the person who otherwise occupied it. But once the information is accurate and is identified by the House, they officially communicate to the Electoral Commission,
okay,
who then, within the stated period, a month, conduct a fresh elections, and then the seat is occupied, depending on the time of the year that we find ourselves in. Because when it's close to an election year, usually the seat will not be contested. It will be part of the general election. That seat will remain vacant until the election. So
now the Speaker has said in his letter declining, to declare the seat vacant, that the case in court is still pending, and so there's not been conclusion to that matter. We know that the MP in question has filed a stay of execution. He's already challenging the Cape Coast High Court's decision. So where do we go from here then?
Indeed, as lawyer Afeni Markins rightly pointed out, once there is a stay of execution, indeed, nothing can happen. You have to wait. Every person has to wait until the state application for stay of execution is determined, whether against or for. Now, depending on where it goes, that will determine the way forward. I know we are not discussing the Speaker's communique, so I really want to comment on that unless it is part of our discussion.
I mean, it is, because then there are doubts in the minds of some people, because then the courts, in its own wisdom, decided to write to the Speaker on this. The Speaker declining, citing Articles 117, 118, and also the fact that the case is still in court. So that's why the Speaker declined the invitation to declare the seat vacant. So I'm asking...
Actually, that is not accurate. The Speaker declined primarily to declare the seat vacant because ostensibly he had received information from the lawyers of the Member of Parliament. This is the basis for his conduct, and I completely disagree with the Speaker. The Speaker doesn't have that authority to act on information received outside of the official channels. He doesn't have that authority. He acts on information appropriately received. The Speaker is supposed to be served through the clerk, and this information he received from the lawyers are not the court officers, and so the lawyers are not, probably they cannot serve the Speaker with anything. And so I was completely surprised. In fact, it's highly improper that the Speaker would act on the information received from the lawyers of the Member of Parliament. Really, what this means is it tends to give credence to a bit of party politicking here, rather than doing law, because appropriately so-called, what ought to have happened is what happened with the second information, i.e. the order from the court. It's supposed to come from the court. It's a court process.
Right.
Similarly, if the lawyer for the Member of Parliament wanted to inform the Speaker of the tendency of the application for stay of execution, all they needed to do was to have gone through the appropriate channels by ensuring that the judiciary, the bailiffs, bring a copy of it to the Clerk of Parliament, who will then inform the Speaker. But this one, we don't even know where the Speaker got it from, how he got this information. Maybe simply because maybe one lawyer of the Member of Parliament or the Member of Parliament knows the Speaker, so they probably will meet him over a lunch or meet him somewhere else or in his private house and give him a copy of it. And on the basis of that, he's acting. That is wrong. We all understand. We all know that there is indeed a stay of execution. But the Speaker doesn't act on that information simply because it is in the grapevine or in the news. He acts upon it because he has been appropriately served with that.
Okay.